Death Row's Final Countdown, every execution in the U.S. from August to December 2025. Welcome back to Justice Reversed, where real crimes meet real justice. Today, we're breaking down the final execution list in the U.S. for August through December 2025. These are the last names still left on America's death row. Number 1, Byron Black. He didn't just take a life, he took 3. A mother and her 2 young daughters, all shot execution style in their beds. And for more than 3 decades, Byron Lewis Black has remained on Tennessee's death row, the center of one of the state's longest-running capital cases. On March 28, 1988, police in Nashville were called to a quiet home in the Bordeaux neighborhood. Inside, they found a scene of unimaginable horror. Angela Clay, 29, had been shot in the head as she slept. Her 9-year-old daughter, Latoya, had been shot through the chest and neck. 6-year-old Lakeisha, the youngest, had been shot twice, once in the chest, once in the pelvis, and appeared to have struggled in her final moments. An abrasion on her arm suggested a last attempt to protect herself. Medical experts determined she remained conscious for up to 30 minutes before dying. The brutality stunned even veteran officers. One retired officer later said that scene would haunt him for life. Prosecutors called it torture. A Tennessee jury agreed. Angela Clay had been dating Byron Black. In the days leading up to the murders, witnesses said the couple had been fighting. Black had allegedly threatened to kill her. On the night of the murders, all 3 victims were in bed, possibly asleep when Black entered the home. There were no signs of forced entry, but plenty of evidence pointing to a premeditated act. Angela's murder was cold, but it was Lakeisha's death that triggered the state's harshest penalty. The jury found the murder was especially heinous, atrocious, or cruel, noting that it involved both physical and mental suffering before death. They also cited multiple aggravating factors: the killing of more than one person, a prior violent felony, and the intent to avoid arrest. Black had previously shot Angela's estranged husband with the same weapon used in the Clay murders. In 1989, Byron Black was sentenced to death for killing Lakeisha. For the murders of Angela and Latoya, the jury deadlocked on the death penalty. He received 2 life sentences instead. Since then, his case has wound through every level of the American legal system. Black has filed appeals on everything from ineffective legal counsel to the constitutionality of electrocution. None have reversed his sentence. But one claim has endured: that he is intellectually disabled and therefore ineligible for execution. Over the years, Black's lawyers have presented IQ scores hovering near 70, claims of schizophrenia, and evidence of brain damage. Tennessee courts, however, found that he failed to demonstrate intellectual disability under the legal standard: low IQ, adaptive deficits, and onset before age 18. In 2021, when the state revised its criteria, eliminating the fixed IQ of 70 or below rule, Black filed again. This time, even the Davidson County District Attorney agreed Black met the revised standard and should be removed from death row. But the court rejected the appeal, ruling that his disability claim had already been adjudicated. The case would not be reopened. The debate over his mental capacity has divided the legal community. Supporters argue that Black's cognitive impairments, combined with poor legal representation at trial, should exempt him from execution. Critics, including the victim's family, see things differently. Angela's sister, Lynette Bell, said the idea that Black didn't know what he was doing was insulting. She described Angela as a good woman, a caring mother, and insisted the crime was calculated, not confused. He knew exactly what he was doing, she said. Today, Byron Lewis Black remains on death row at Riverbend Maximum Security Institution. His execution is set for August 5, 2025. Tennessee law allows him to choose his method of execution: electrocution or lethal injection. Either way, his case will mark the first execution under the state's new one-drug protocol since a moratorium paused executions in 2022. There is no dispute about his guilt. The question, now, is whether the state should end the life of a man some say is too impaired to understand his punishment, and whether the years of appeals, delays, and legal complexities have brought closure to those who lost the most. What happened to Angela, Latoya, and Lakeisha was irreversible. The decisions made in courtrooms since have tried to weigh justice against mercy, legality against morality. The emotional weight of this case can't be measured by sentencing orders alone. It demands hard reflection. When domestic abuse is ignored or minimized, it can escalate to irreversible tragedy. Mental health concerns must be evaluated early, not after violence occurs. Lengthy appeals should not obscure the voices of victims or diminish their loss. And legal reforms mean little if courts refuse to revisit past cases with new standards. As Tennessee prepares to move forward with execution, the question lingers: when the system takes this long to decide, is anyone truly satisfied with how it ends? Number 2. David L. Roberts. In the early morning hours of April 22, 1992, a house in Marion County, Alabama erupted into flames. Fire crews found more than just charred debris. Inside, on a smoldering couch, lay the body of Antra Jones. She had been shot 3 times in the head as she slept and then set on fire. The man responsible was 41-year-old David Lee Roberts, a guest in the same house. Roberts wasn't a stranger. He had been staying with Jones' boyfriend, who was away at the time. Jones was sleeping on the couch, unaware that her final moments were already in motion. At some point that night, Roberts packed his belongings, took money from her wallet, picked up a .22 caliber rifle, and fired 3 rounds into her head while she slept. Then he doused her and the floor in gasoline and set 2 separate fires, one in the living room, another in a back room, in a calculated attempt to destroy the evidence. Prosecutors would later call it premeditated, cold, depraved. The crime shocked the rural Alabama community. Roberts confessed, though his explanations changed. First, he said he acted under threats from Jones' boyfriend. Later, he claimed not to know why he did it, only that he had tried to burn the house down afterward because of vague threats. What didn't change was the brutality. Shooting a sleeping woman in the head 3 times. Setting her corpse in the house on fire. Stealing from her. The details painted a picture of a killing not born of passion, but of intent. In 1994, a jury convicted Roberts of capital murder. But when it came time for sentencing, they stopped short of the ultimate punishment. The jury voted 7-5 to recommend life without parole. Yet under Alabama law at the time, a judge could override the decision, and he did. David Lee Roberts was sentenced to death. That practice, once common in Alabama, has since been abolished. Judges in the state can no longer overrule a jury's recommendation in capital cases. But Roberts was sentenced before that reform, and the law doesn't apply retroactively. He's been on Alabama's death row ever since. Over the years, Roberts' legal team has argued that he should never have been sentenced to death, not because he didn't commit the crime, but because of what they say is a lifetime of severe mental illness. Doctors have diagnosed Roberts with paranoid schizophrenia. Court records show he has experienced hallucinations, delusions, and disorganized thinking. A prison psychologist reported in early 2025 that Roberts was hearing voices and suffering from persistent psychosis. His attorneys describe his mental condition as well documented and deteriorating. Under U.S. law, the state cannot execute a person who is mentally incompetent, someone who cannot understand the fact of their execution or the reason for it. Roberts' attorney argued he likely meets that threshold and sought a delay for further psychiatric evaluation. The state of Alabama disagreed. The Alabama Supreme Court sided with the state, authorizing his execution. Roberts chose nitrogen hypoxia as his method of execution, a process in which pure nitrogen is pumped through a mask, depriving the brain of oxygen. It is a new and controversial method, first used in 2024. If carried out, his death would mark the 7th execution by nitrogen gas in the U.S., and the 4th in Alabama this year alone. His execution is scheduled to occur between midnight and 6 a.m. on August 22, 2025. The case has stirred national debate, not over his guilt, but over the ethics of executing a severely mentally ill inmate using a method some have called cruel and experimental. Organizations worldwide, including the Vatican, have condemned nitrogen hypoxia. Legal scholars question whether such a method meets constitutional standards. Yet Alabama continues to defend its legality. There is no known public statement from Antra Jones' family about the execution. But her death, senseless, brutal, and hidden beneath fire, remains a devastating loss. David Lee Roberts confessed. He pulled the trigger. He lit the match. And now, more than 30 years later, the state prepares to end his life. But the case raises questions that go beyond crime and punishment. When a jury rejects death, should a judge be allowed to overrule? When mental illness clouds reality, does justice remain clear? This case reminds us why the justice system demands not only legal precision, but moral awareness. A jury's decision must be respected, and when judicial override silences that voice, trust erodes. Mental illness must be thoroughly evaluated in all stages of trial, not just at the end. New execution methods demand full transparency before implementation, not after controversy erupts. And sentencing laws should not apply retroactively without review of cases affected. And when executions move forward despite medical alarms and moral debate, what exactly is being upheld? Justice? Or something far more complicated? Number 3, Blaine Milam. She was only 13 months old. Her name was Amora Carson. The cause of her death wasn't an accident, nor was it a sudden act of rage. What happened to her was ritualized, prolonged, and deliberate, a horror masked as spiritual cleansing, carried out by the people who were supposed to protect her. In December 2008, Rusk County, Texas, became the site of one of the most disturbing child murder cases in state history. Amora was found dead in a trailer home, the victim of what her mother and her mother's boyfriend claimed was an exorcism. The boyfriend, 19-year-old Blaine Keith Milam, was convicted of capital murder. According to prosecutors, Milam and Jessica Carson, Amora's mother, believed the toddler was possessed by demons. In their delusion, they subjected her to unspeakable brutality. The autopsy revealed that Amora had suffered extensive internal and external injuries. She had been beaten with a blunt object, likely a pipe wrench. She had been strangled. Her small body bore 24 bite marks, later determined to have come from both Milam and Carson. Most disturbingly, she had been sexually mutilated. The medical examiner described it as the most horrifying case of child abuse he had ever seen. Milam initially called 911, claiming to have discovered the child unresponsive. He suggested there had been a break-in. That story quickly unraveled. Investigators found no evidence of forced entry. They did, however, find evidence of deception. Carson had asked her aunt to hide the pipe wrench believed to be the murder weapon. The prosecution built its case around the sheer brutality of the crime and the deliberate steps taken afterward to mislead investigators. Texas law classifies the murder of a child under 10 as a capital offense. The underlying allegations of sexual assault and the extensive nature of the injuries further supported the capital charge. A jury convicted Milam and sentenced him to death after long deliberation. Jessica Carson, meanwhile, received a life sentence without the possibility of parole. Milam's defense team argued that Carson had been the primary aggressor and that Milam's role was secondary. But under Texas's law of parties, he could be sentenced to death if found to have shared intent or participated knowingly in the crime. After his conviction, Milam's legal battle continued. His attorneys argued that he was intellectually disabled, presenting evidence that he functions at the level of a 13 to 14-year-old and struggles with reading and cognitive reasoning. According to U.S. Supreme Court precedent, individuals with intellectual disabilities are constitutionally protected from execution. Compounding the legal complexity was the use of bite mark evidence, a forensic technique once accepted, now largely discredited. Milam's defense cited the Texas Forensic Science Commission's 2016 call for a moratorium on such evidence and argued that the prosecution's reliance on it tainted the integrity of the trial. In 2019, Milam's execution was stayed just one day before it was scheduled to occur. The Texas Court of Criminal Appeals ordered a lower court to reconsider the case in light of evolving scientific and legal standards, particularly the intellectual disability claims and the bite mark testimony. Another stay was granted in 2021. Still, federal courts declined to intervene. Milam's appeals were repeatedly denied by the U.S. Supreme Court and the Fifth Circuit Court of Appeals. Despite these setbacks, his legal team persisted, gaining the support of advocacy groups such as the ARC of the United States and Disability Rights Texas, who argue that executing Milam would violate constitutional protections. His new execution date is set for September 25, 2025. Amora's grandfather, Richard Mutena, gave a victim impact statement after the sentencing. He said the decision gave his family a sense of closure. "I spoke for Amora and I spoke for my family," he said. "It took a lot off my chest." But outside the courtroom, the debate endures. Can a man with intellectual limitations convicted under a now questioned forensic theory truly receive a fair and constitutional sentence? And how do we reconcile a justice system where one participant gets life and another death? And that's where the caution begins. If forensic science can be wrong, we must be cautious in using it to justify death. When intellectual disabilities go undiagnosed or ignored, justice risks turning punitive instead of fair. Sentencing disparities, life for one, death for another, require deeper scrutiny, especially in shared crime cases. Laws like the law of parties need rigorous reevaluation when used to assign death. Blaine Milam remains on death row. The brutality of what happened to Amora Carson is not in dispute, but the questions raised by his case go beyond guilt and innocence and to the very foundations of how we define responsibility, fairness, and justice in America. Number 4, Lance C. Shockley. It wasn't a drug turf dispute. It wasn't a crime of passion. It was the execution of a state trooper, and what followed wasn't just a trial, but a legal storm that exposed cracks in the death penalty process. Lance Shockley's case is not only about guilt, it's about how justice is decided. In March 2005, Missouri State Highway Patrol Sergeant Dwayne Graham was shot and killed. He had been investigating a fatal one-vehicle crash involving Lance Shockley, a crash that killed a family member of Shockley's and led to charges of involuntary manslaughter and leaving the scene. Before Graham could bring formal charges, he was dead. Shockley was arrested and charged with first-degree murder. The charge alone implies premeditation, that Graham's killing was not spontaneous but planned. What Shockley feared from Graham's investigation, he tried to silence permanently. The exact method of the killing was not made a focus of media reporting, but what unfolded after his arrest would become a focal point for legal scholars, judges, and even U.S. Supreme Court justices. Shockley's trial concluded with a conviction, but the jury deadlocked during the sentencing phase. In most U.S. states, that means a life sentence by default. But Missouri, one of only 2 states allowing it, grants judges the power to impose a death sentence when the jury cannot reach a unanimous decision. And that's what happened. The judge sentenced Lance Shockley to death. The conviction might have stood as another example of Missouri's strict capital punishment policy. But after the trial, serious concerns emerged, not about the murder charge itself, but about how the verdict had been reached. It began with the jury foreman. During the trial, he never disclosed that he had self-published a book, a fictionalized account involving the brutal and graphic revenge murder of a defendant who killed the protagonist's wife in a drunk driving accident. After the verdict, it came to light that he had brought the book into the jury room and shared it with others during deliberations. The parallels were chilling. Shockley had been under investigation for a fatal crash. The fictional killer in the book had caused a fatal crash. The book ended in violent revenge, and it was written by the man helping decide Shockley's fate. Shockley's lawyer moved for a mistrial, citing the foreman's misconduct. The judge offered the attorney the chance to question the foreman and jurors under oath. But, inexplicably, the attorney declined. He presented no witnesses, conducted no examination, and walked away from the very evidence that could have saved his client's life. Years later, Justice Sonia Sotomayor would write that the attorney's failures could fail to constitute ineffective assistance of counsel, one of the most basic protections guaranteed under the Sixth Amendment. Shockley appealed, arguing that his lawyer's performance denied him a fair trial. But the Eighth Circuit Court of Appeals refused to hear his claim. The issue came down to a technicality: the legal rules governing how federal courts issue certificates of appealability, or COAs. Other circuit courts interpret these rules more leniently, meaning that in a different region of the country, Shockley's appeal may have been heard. Justice Sotomayor dissented again when the U.S. Supreme Court declined to review his case in 2025. She noted that 36 death row inmates had been denied review that year alone. She warned that the severity of the underlying misconduct and the defense attorney's failure to vindicate his client's rights warranted serious scrutiny. But the court let the verdict stand. No retrial. No hearing. Shockley's execution date was set for October 14th. The Death Penalty Information Center later flagged the case in its reporting. While not calling for clemency directly, their analysis underscored what legal experts called a troubling procedural failure. There is no public record of Sergeant Graham's family speaking out about the sentence. And the method of execution has not been publicly confirmed, but in Missouri, lethal injection remains the primary option. The murder of a law enforcement officer is among the most serious crimes in any justice system. But so is the possibility that a man's life was decided not solely by evidence, but by a fictional novel, hidden bias, and legal technicalities. What happened in that jury room, and what didn't happen afterward, raises hard truths we can't ignore. Jury misconduct must be fully investigated, no matter how damning the crime. Defense attorneys in capital trials bear a sacred duty. Failure is not just error, it's consequence. Judicial overrides of jury indecision should be re-examined where they still exist. Lance Shockley was found guilty of murder. But what his case ultimately puts on trial is the system itself and what happens when due process bends under the weight of silence, oversight, and a judge's final word. Number 5. Harold Nichols. It wasn't her attacker's first time. It wasn't even his fifth. By the time Harold Wayne Nichols broke into 21-year-old Karen Pulley's home in 1988, he had already raped multiple women across Chattanooga. What happened next was only the latest in a violent pattern, and the one that would finally stop him. Karen Pulley was alone at home when Nichols forced his way in. He raped her, and when she resisted, he beat her in the head with a 2x4. After the assault, he struck her again not once, but several times, with enough force to leave her in a pool of blood. She was still alive when help arrived but died the next day. Nichols was arrested in 1989. During questioning, he confessed to Karen's murder and to a string of other rapes. Police identified him as a primary suspect in numerous assaults in the area. Court records show that until his arrest, Nichols would roam the streets at night, targeting women. He later admitted that if not caught, he would have continued. He pled guilty to first-degree felony murder, aggravated rape, and burglary. But despite the guilty plea, the case went to sentencing, where prosecutors detailed not just Karen's brutal death but Nichols' history. Within 3 months of the murder, he had already been convicted of 5 aggravated rapes involving 4 other women. He had also been charged with attempted rape in up to 12 additional cases. A jury sentenced him to death, citing 2 aggravating factors: his prior convictions and the fact that Karen was murdered during the commission of a felony. Although Tennessee's High Court later ruled it unconstitutional to use felony murder both as a charge and as an aggravating factor, they upheld the sentence, saying the prior rapes alone justified it. What made Nichols' case more disturbing was his own explanation. In court, he described feeling a strange energized compulsion before each attack. A psychologist diagnosed him with intermittent explosive disorder, triggered by unresolved rage from childhood trauma. His mother died when he was 10. He and his sister were left with an abusive father, described in court as physically and sexually violent. The children were later placed in an orphanage. Nichols expressed remorse for his crimes, but also admitted he likely would have continued attacking women if not arrested. Over the decades, his defense team raised numerous issues on appeal, jury selection, access to psychological notes, the use of prior crimes in court, and the legality of his taped confession. The Tennessee Supreme Court upheld his conviction and sentence in 1994. Chief Justice Reed dissented, arguing that Nichols' case didn't meet the highest bar for capital punishment and warning that the court's proportionality review was flawed. In 2018, Chattanooga prosecutors agreed that Nichols should be eligible for resentencing to life under a revised state law. But a judge rejected the agreement. His execution was originally set for August 2020 but delayed due to the COVID-19 pandemic. A new date was scheduled for June 9, 2022. Tennessee law gives Nichols the choice between lethal injection or electrocution, and he remains on death row at Riverbend Maximum Security Institution, awaiting final notice. Public campaigns for clemency have been minimal. On the contrary, victims' families have spoken out demanding the sentence be carried out. Carlane Hicks and Karen Adams, both affected by Nichols' crimes, said they've waited decades. "Let us go on with life," Hicks told reporters. "Let us see this happen." While the case has not led to major legal reforms, it contributed to Tennessee's internal debates over the use of aggravating factors, jury procedure, and the handling of mental health claims in death penalty cases. The dissenting opinion in Nichols' appeal remains cited in legal discussions around proportionality and due process in capital cases. And here's where the caution begins. When violent impulses persist unchecked, early intervention can save lives. When mental health issues stem from trauma, diagnosis must come before escalation. Using prior crimes as sentencing aggravators requires careful proportionality, not automatic enhancement. Judicial override of jury verdicts demands transparency, especially when capital punishment is at stake. Harold Wayne Nichols is not accused of a single act of violence. He confessed to a pattern calculated, repeated, and brutal. The question his case leaves behind is not about guilt, but about limits. When childhood trauma, mental illness, and a legal system all fail at once, who decides what justice should look like? Number 6. Geoffrey Todd West. It wasn't confusing. It wasn't a robbery gone wrong. It was a decision clear, deliberate, and final. Margaret Berry did everything she was told. She gave up the money. She lay face down on the floor. And still, Geoffrey Todd West ended her life with a bullet to the back of her head. The murder took place just after midnight on March 28, 1997, at Harold's Chevron, a small gas station in Alabama. Margaret Berry, the night shift clerk, was working alone. West had worked there in the past. That night, he returned with a .45 caliber handgun and a plan. He ordered Berry to hand over $250 in cash from a cookie tin behind the counter. She complied. Then, he told her to lie flat behind the counter. She did exactly as instructed. There was no panic, no resistance. But West had already told others what he intended to do: rob the store and leave no witnesses. He followed through exactly as promised. He pulled the trigger once. The bullet caused immediate incapacitation and almost instantaneous death. The autopsy confirmed there was no chance of survival. She died with her face to the floor, offering no threat and asking for nothing. West was arrested not long after the killing. Prosecutors charged him with capital murder. In Alabama, a murder committed during a robbery is a death-eligible offense under the law. The jury voted 10-2 in favor of the death penalty. The trial judge accepted the recommendation and sentenced West to die. There was no mystery about what happened. Witnesses recalled West discussing his plans before the crime. The forensic evidence matched the crime scene. There were no claims of mistaken identity. West didn't argue mental illness, trauma, or coercion. His legal team focused on technical matters. The guilt was undeniable. The sentence was clear. Years later, West joined other inmates in a legal challenge to Alabama's method of execution. The focus wasn't on overturning convictions, it was about the process of lethal injection. Alabama had faced mounting criticism for botched executions using outdated drugs. In 2018, the state responded by approving nitrogen hypoxia as an alternative method. Nitrogen hypoxia involves replacing oxygen with pure nitrogen, causing death by asphyxiation. It was authorized as a legal option for death row inmates who had been sentenced before June 30, 2018. West was one of them. He elected this method, a decision that meant the state could no longer execute him by lethal injection. The Federal Defender's Office, which represents West and others, made it clear that by choosing nitrogen hypoxia, inmates had not waived their right to challenge how the procedure is carried out. They demanded that the Alabama Department of Corrections make public its execution protocol, citing transparency and constitutional requirements. As of now, Geoffrey Todd West is expected to officially carry out his death sentence in July this year. His case no longer centers on guilt or innocence. It has become part of a broader legal and moral conversation about how the state takes life in return. No public statements have been made by Margaret Berry's family about the sentence or West's appeals. But the facts remain: she was 100% compliant. She gave up the money. She lay still on the floor. And she was still killed. The core of this case isn't about complexity. It's about simplicity, the horrifying simplicity of a plan followed through. A woman's life ended not because she resisted, but because her killer had always planned it that way. And now, decades later, the conversation has shifted. Not about whether the West should be punished, but about how. About which method is acceptable. About what the Constitution allows. And about whether justice delayed by process still feels like justice at all. When someone calmly plans a killing, carries it out with precision, and then spends the rest of his life arguing about how he'll die, it leaves us asking something deeper. Here's where caution should guide reflection. A crime planned down to silence demands that juries and judges scrutinize motive and mindset. When execution methods remain untested or controversial, transparency must precede implementation. Victims who comply fully raise urgent questions about planning and failure in prevention. Legal processes should not let procedure overshadow moral gravity, especially in capital cases. What do we gain by waiting? What do we lose when we reduce a human life to courtroom timelines, procedure manuals, and execution protocols? And at what point does justice become so measured, it forgets the weight of what was done? Some of these names will disappear quietly. Others might spark last-minute legal wars, protests, even political backlash. But all of them, every man on this list, is running out of time. And here's the twist: not all of them may die as scheduled. Secret clemency pleas, disputed science, missing evidence, even a single affidavit could change everything in the final hours. Who will actually make it to the execution chamber? And which case will explode into the next national controversy? To find out first, subscribe to Justice Reversed and tap the bell icon, because the stories we're about to cover next are even darker than the ones you've just heard. The countdown isn't over. It's only just begun.